An entrepreneur should try to find someone that they feel they can work with, someone that they feel shares their vision for the business that they want to build. I don't think an entrepreneur should wait until they're at the fundraising stage to engage counsel. If you wait until you have a term sheet from a financial source to start to think about getting legal counsel, that can really upset your plans, because what will happen is the financial source is going to engage eminent counsel, and that counsel is going to begin to ask a lot of questions and delve into the nature of the company that you have formed. If the answers are not right, you're going to lose credibility as an entrepreneur with the financial source. And if the answers are not right, but the financial source is not turned off by the opportunity, it's then going to cause a big delay, because the financial source is going to ask you as the entrepreneur to step back and build up this enterprise in a way that they want to see it built. Characteristic that they all share is a characteristic of limited liability, which means that when an entrepreneur functions through a corporation or through a limited liability company, the only thing that they have at risk is the amount of capital, or the resources that they have invested in that entity, and their own personal resources are not on the line at that time. A corporation has a statute, usually they'll be formed under statutes that have many, many restrictions on what you can do, on how you can operate that business. From a financial standpoint, from what you have to receive in order to issue additional equity interest in that company, for example, the kinds of votes that you need to take internally in order to perform certain tasks or enter into certain transactions. So there are certain limits there. Whereas with a limited liability company, the sky's the limit. Those statutes were set up in such a way that they free the entrepreneur to create whatever structures they want within the framework of a limited liability company. So there's more leeway that the entrepreneur has in setting up the different kinds of things that they want to see in the management of their entity, in the way that interests are transferred, in who can become a participant in that entity. They're freer in the limited liability company format. A corporation is typically an entity that itself is taxed, so that the entity is going to pay a tax on its income, and the only thing that can be passed down in the form of a distribution, which for a corporation is a dividend, that can be passed down to the equity owners of the corporation, is net of the amount of tax that has been levied against the net income, or the income of the enterprise. With a limited liability company, you can elect to have the limited liability company function as a pass-through vehicle, which means that the limited liability company itself is not taxed on its income. I always thought that the business plan was something that the venture capitalist or the angel was going to rely on when they were making an investment in the entrepreneur's business. And after speaking with the VCs and with the angels and having them on my panels, it's absolutely not the case. They do not really find the business plan of any importance to them. They do their own research into the size of the market. They do their own research into who the competitors for the business are. What they believe the business plan is important for is for the entrepreneur, him or herself, that the entrepreneur, in writing that business plan, really learns more about their business than they knew before. In addition to venture capital financing, we advise them on friends and family rounds. We advise them on SBA loans. We might advise them on helping them to find a banker that might give them a good hearing. There are times when we can advise an entrepreneur to take debt financing, but generally that's not going to be at a very early stage. But what we have found that is more successful with a young company that is willing to take in indebtedness, and with creditors who are willing to give them a debt instrument, we usually do that as a convertible debt. And the way that we structure that usually is that the debt will be put in, and the convertibility of that debt will be based upon certain milestones being hit. What that allows the entrepreneur to do is it allows him or her to take in what is in essence an equity investment, but without dealing with the valuation discussion. When a company is at a very early stage, it's very difficult to place a value on that enterprise. And that's usually a pretty contentious discussion with the entrepreneur. But if you can structure something that allows the entrepreneur to take in a debt-like instrument without having the valuation discussion, you really benefited the entrepreneur, and you've sped up the process of getting the money in that is necessary to allow the company to grow so that they can get to the point in time in which they can take in a more traditional equity investment. The level of protection that an entrepreneur should apply to their intellectual property is dependent upon the value of that intellectual property to the enterprise. Branding is very important, and we advise clients on branding routinely. We advise them about trademarking their names, trademarking their logos, and making certain that the name that they pick and the logo that they pick is something that is protectable. A good accountant can help the entrepreneur to structure the financial reporting that they provide to their financial sources. A good accountant can also help the entrepreneur anticipate liquidity crunches that might occur in their business as they operate it. And they can help them anticipate when those liquidity crunches are going to develop and strategies, methods for dealing with those liquidity crunches. I think that's very important, and accountants provide a very important service to entrepreneurs. And I always tell them to obtain an accountant at the very earliest stages. Other than not using the best documents for the building of their businesses, I think one of the biggest mistakes that an entrepreneur can make is selecting the wrong partners. So one of the things that you should craft into the documents that they use around the organization of the business is what happens if one of the musketeers wants to leave before the building is built. If they haven't made arrangements in the organizational documents to account for what happens if there's an early departure, then someone who is early departing still will hold on to all the equity that they had. So let's say that person had a third of the equity. Well, to bring in that same function, they may have to give away another third of the equity of that company, and that is going to be much more dilutive to the remaining partners, and the partner who left is going to keep a much greater piece of the entity than that person should have, and that's going to be something that is going to bite them later on if they haven't accounted for a vesting in of the equity, so that if someone leaves early, they don't get to retain all the equity that they were originally granted. Be flexible and expect the unexpected. Really, the entrepreneurial mission is something that does not have a set track to it. Things change. Things that you thought were going to happen tend not to happen, or they don't happen as rapidly as you thought. It takes longer to get the financing that you need than you thought it would, and your partners might not always be there with you and be as fully supportive as you thought they were going to be. So you have to be flexible, and you have to expect the unexpected.